Well, good afternoon. My name is Bob Lutz. I'm a professor of law at Southwestern Law School and teach in the area of international private and public law. I have the admirable, I think, but modest role as moderator, so I will proceed moderately and thank, first of all, the Pepperdine Law School and Trey Childress and Jack Coe and the many very excellent students that have put this program together. We're between you and happy hour, so we'll keep that in mind. But I want to emphasize a point that Trey did earlier, and that is that this is a focus on, in one respect, the process that really matters, the back end of the process of judgment, recognition, and enforcement, and award, enforcement, and recognition. And so today we have a very interesting panel, I think you will find, where the mixture of courts and the arbitration process comes into play and into sometimes conflict and also into concurrence. And we have the benefit of several very interesting scholars and accomplished scholars with significant arbitration experience behind them. Maxie Shearer is now a senior lecturer at Queen Mary University of London, teaches in the LLM program, focuses on international arbitration, and is director of the LLM in Paris, and also co-counsel with Wilmer Hale in London. And Adam Simowitz is a research fellow at the NY Center for Transnational Litigation, Arbitration, and Commercial Law, and a fellow at the Classical Liberal Institute. Co-teaches international litigation and arbitration at NYU, and last year he was also taught a course at Columbia Law School. Aaron will focus us on some recent Supreme Court jurisprudence, namely the Daimler versus Baumann case and the impact it has on jurisdiction over intangibles. And Maxie will follow with an analysis of the judgment route in international arbitration, referring to the trend of jurisdictions to grant effect to foreign judgments related to arbitral awards. Those are very brief synopses, and they will elaborate on them. Aaron?
I said everything.
Okay, let's go home.
First, thank you very much to the Pepperdine University School of Law, to the Pepperdine Law Review, to Jack, Trey, and Tom, and Catherine and Sarah for both this invitation and putting on this wonderful conference. I've heard many reports of the wonderful events here at Pepperdine, and if anything, those reports were understatement. Second, I want to thank my co-author on this project, Linda Silberman. I know she would love to be here. I think she is sort of here in spirit, since she has collaborated with both me and Maxie on various projects, and I think has informed our thinking on them. And third, I'd like to thank all of you here in the studio and at home for hanging in with us for the last panel of the day. Now, without further ado, as Andy Lowenfeld would say, on to mere substance. I'm going to be talking about what hath Daimler wrought, new obstacles for award enforcement. And by the way, that symbol in the background is the Turkcell logo, the logo of the largest mobile phone company in Turkey, and you'll find out why that's relevant in just a minute. But first I'm going to start you off with two statements about enforcement and jurisdiction. The first, you have a statement from the First Department, which is the Intermediate State Appellate Court in Manhattan, saying a petition for recognition enforcement requires no jurisdictional nexus at all. It requires no connection to the state, to the court where enforcement is sought. The Constitution does not impose it. And here you have a second statement from the Second Circuit, another court in New York, that says a petition for recognition enforcement absolutely requires a jurisdictional nexus. It has to have some connection to New York, either personal jurisdiction or asset jurisdiction. What is the difference, you ask? The first sentence is about recognition of foreign money judgments. The law in New York, at least, is that they require no jurisdictional connection to New York. The second sentence, if you can believe it, is about arbitral awards, saying that arbitral awards do require a connection to New York for them to be recognized and enforced there. Now I make a couple observations about this dichotomy. Number one, it makes no sense whatsoever. I can think of no defensible reason why recognition and enforcement of arbitral awards should be more onerous. Bear in mind, this process is governed by the New York Convention, a rather successful international treaty. I can think of no reason why that should be more onerous than the recognition and enforcement of foreign country money judgments, which is governed by no treaty. And yet that is the law as it stands now, but this has not been a significant problem because we have traditionally had in the US very broad general jurisdiction. And that meant if you had any sort of big multinational that was doing much of anything in the US, you could get it here, you could get a jurisdictional connection in the US, and that was true up until about 15 months ago when this happened. This is not Mercedes introducing its new E-Class. That may also have happened, I don't really know. What happened on January 14th of last year is the Supreme Court decided Daimler v. Baumann. And what Daimler did in that case was to radically cut back on, to radically limit the US law of general jurisdiction. And just a quick refresher on this stuff. To exercise power over a party, generally speaking, a US court needs personal jurisdiction over the party, and that comes in two flavors, one of which is specific jurisdiction, sometimes called claim-specific jurisdiction. And that requires that you have jurisdictional contacts that arise out of or are related to the claim. So you did something bad in New York, and you get sued in New York for the bad thing you done. Then there's general jurisdiction, or all-purpose jurisdiction, which is you have so many connections to, let's say, New York. Sorry, I keep using New York as an example. It's where I'm from. That you can be sued there for anything. It's claim non-specific jurisdiction. And that's what was usually used in award recognition enforcement, and that's what the court radically cut back from the old standard of continuous and systematic contacts to essentially at home. And to give you some idea of what that means and how radical that is, here are some examples on facts that grounded general all-purpose jurisdiction pre-Daimler. You could do a bunch of sort of, finance-related activities. You could have a small but permanent sales office, or you could rent a couple rooms with a few low-level employees not doing much of anything at all. And for that, you could be sued for anything in the US. After Daimler, that's it. Place of incorporation, principal place of business, or exceptional circumstances. And the court really does seem to mean exceptional. The example they look to is the Perkins case, the only other time the Supreme Court has taken up general jurisdiction, which was a case where a Philippines company essentially fled to Ohio and set up all their operations there because they were fleeing the Japanese invasion of the Philippines. So exceptional really does seem to mean exceptional. So why is the court doing this? Well, the court wants to get these so-called F-cubed cases out of the US, cases where you have foreign plaintiff, foreign conduct, foreign defendant. Indeed, that's what was going on in Daimler. You had Argentine plaintiffs, Argentine conduct, and a German defendant. And Justice Ginsburg wrote she wanted to bring the US law sort of closer to the law of most nations. EU, for example, where domicile is the central plank of jurisdiction. Did that work? Did the court accomplish what it set out to do? Well, certainly foreign defendants are less likely to be hailed into US courts. But maybe it overshot the mark. Because what Justice Ginsburg didn't really grapple with was that because of some other recent Supreme Court decisions, Nicastro being the biggest, specific jurisdiction, has now gotten really small in the US too. The great example is point of injury jurisdiction. In most countries, if you're hurt somewhere, you get to sue there. Not so in the US. So now what we have in the US is really small general jurisdiction and really small specific jurisdiction. So maybe the court overshot the mark, but maybe it also made unintentional alterations to other areas of US law that have really grown up around this very broad conception of general jurisdiction. And now we come back to that problem of the jurisdictional nexus for arbitral award enforcement. Again, a sort of lightning review of arbitration award enforcement. I think we can all agree that ease of enforcement of arbitral awards is crucially important. It's governed by the New York Convention, which in Article 5 provides a list of supposedly exclusive defenses to recognition enforcement of awards. But of course, that's not really true, at least in the US, because US courts have interposed various so-called including the jurisdictional nexus requirement. And in fact, it's not just the Second Circuit, but every federal court to take up this question of is jurisdiction required to enforce an arbitral award have emphatically said yes, either personal jurisdiction or asset jurisdiction, which is to say the debtor has stuff in New York, let's say, that you want to seize. So assets are personal jurisdiction, except for the Fourth Circuit, which said, I think very bizarrely, that even assets are not enough, you need personal jurisdiction. And all of this comes to a head in the Turkcell case recently from the Second Circuit, which goes by the name of Sonera v. Kukurova. And what happened in that case is you had a Geneva seat award of nearly $1 billion that the award creditor sought to get recognition and enforcement of in New York. The district court said you could do it pre-Daimler, afterwards. You can guess what happened. Now, what's really going on in this case, by the way, is a fight for corporate control of this massive company, Turkcell. What actually happens here is that Kukurova sells some shares in Turkcell to another holding company, and they find out, much to their displeasure, this holding company is actually controlled by a Russian outfit with the alarming name of the Apex Group. And now knowing this, they suddenly realize that the Apex Group would have a controlling interest in Turkcell, and they're very upset about this. So they start trying to exercise the right of redemption of their shares. Well, the Apex Group wants to stop them. So they go out and acquire this entity that has an outstanding arbitral award against Kukurova, and they start trying to use it to prevent them from using the funds that they need to redeem those shares. And what they do is they bring it to New York. And here are the jurisdictional facts that connected Kukurova to New York, the same sort of stew that we saw as sufficient before Daimler. And indeed, before Daimler, easy case for general jurisdiction. After Daimler, easy case for no general jurisdiction. And recognition enforcement was denied. And then, not that long ago, cert was denied by the Supreme Court. So now we come to sort of the heart of the issue. And I guess if you remember two slides from this entire presentation, I want it to be this one and the next one. The question is, what effect, if any, should Daimler have on recognition and enforcement of arbitral awards? And I think there are four possibilities. The first is that Daimler applies fully, as in the Turkcell case that we were just talking about. And if Justice Ginsburg were here, she might say, well, maybe you should derive some comfort from the fact that specific jurisdiction can pick up the slack, which maybe is true in merits cases, maybe in the case of plenary jurisdiction, but it's not even really clear what specific jurisdiction, remember, arising out of or related to jurisdiction means in the enforcement context. Right? The jurisdictional context have to arise out of or relate to the action. But the action here is one for recognition and enforcement. You're not being sued because of something you did. You're just being sued so that an arbitral award can be converted into a domestic judgment. So it's not even clear if the alleged contacts need to relate to the action for recognition and enforcement. That's one possibility that a New York court took up in an action seeking recognition and enforcement against a third-party bank that was holding the debtor's assets. And they said, well, I don't think you can make out specific jurisdiction here, but maybe if the debtor had made a fraudulent transfer using the bank to get out from under the judgment. But if you put your jurisdiction hats on for a second, that doesn't make much sense. Because normally we say to subject someone to specific jurisdiction somewhere, they have to have some sort of purposeful conduct directed there. But just because some scofflaw debtor used your bank to make a fraudulent transfer doesn't seem like it's purposeful on behalf of the bank. So that doesn't seem to make much sense. The other option is to say that the jurisdictional contacts have to arise out of or relate to the underlying facts that gave rise to the arbitral dispute. But that also seems unsatisfying because unless the conduct just happens to be in the US, that would effectively just deny recognition and enforcement. So that's option one. Option two is that Daimler applies to defendants, but not to debtors. That Daimler is a case about merits jurisdiction and not about enforcement jurisdiction. And in fact, there's very good doctrinal and theoretical grounding for this. Think back to the old Supreme Court case of Schaffer v. Heitner, which eliminates quasi and rem jurisdiction for merits cases. And that's just to say, after Schaffer, you can no longer be hailed into a court simply because you have property there that's unrelated to the claim. Right? If I have a nice painting in Malibu, I can't be summoned to Malibu to defend any claim just because I have that vase here. But the court says in footnote 36, one of these famous Supreme Court footnotes, that is not true post-judgment. We think once there has been an adjudication, there is no unfairness in having different jurisdictional requirements. And the reason they give is sort of a rare moment of clarity and simplicity in this area of the law. They say, look, if we imposed a personal jurisdiction requirement for judgment enforcement, a scofflaw judgment debtor could just take its assets and put them somewhere where they're not subject to personal jurisdiction, and they would be judgment proof. And the restatement picks up that reasoning. So that's option two, that this very strong, essentially at home, might apply in merits cases, but not in enforcement, and maybe the old continuous and systematic standard could live on for actions to recognize and enforce an arbitral award. Option three is that consent to arbitration is consent to enforcement. And I actually think this is a very appealing position. The notion being, at a minimum, if you consent to a New York convention-governed arbitration, you are consenting to recognition and enforcement of that award in any New York convention country. And consent is a long-standing, traditional basis of jurisdiction in the US, probably still an exception to minimum contacts. And that really solves this whole problem. It deals with this whole issue of jurisdictional nexus by letting the award creditor go to any New York convention country to enforce its award. And indeed, there's a variation on this argument for arbitrations against sovereigns and sovereign instrumentalities, because the Foreign Sovereign Immunities Act in section 1605A6 provides explicit statutory jurisdiction for recognition and enforcement of an arbitral award. And in a sort of very high-profile case, the Pemex case, which is the first case in which a New York court has granted recognition and enforcement to an award set aside at the seat. So everybody knows it, this big case about set-asides of award. After Daimler, there's now also this jurisdictional issue. And the US comes in and files an amicus brief and says, look, State Petroleum Company of Mexico, you agreed to an arbitration with a subsidiary of the US company. You had to know that the US statute, the Foreign Sovereign Immunities Act, gives express statutory jurisdiction in the US for recognition and enforcement of that award. You can't now claim that you had no idea that you were consenting to this action in New York. And the last option, and I credit Rusty Park for this, is consent by contract. That this should be written into the arbitral agreement. Several years ago, Rusty wrote a piece about these so-called non-convention defenses, forum non-conveniens, and personal jurisdiction. And he said, look, if this is a problem, just put a clause in your arbitral agreement that says both parties consent to personal jurisdiction wherever recognition and enforcement of the award is sought. And we didn't see a lot of practitioners taking him up on that, but again, that was before Daimler. And I think as the Sonera case begins to percolate, we're going to see a lot more of that. And indeed, in Sonera, I had the lawyers for Kukurova as guests in my class in the fall, and they said what they were really worried about was this argument, because there was a sort of standard form entry of judgment clause in the arbitral agreement, and they were worried that the Second Circuit would interpret that as consent to recognition and enforcement. Now, I think to answer which of these positions we want, we have to talk about the question of why creditors want to enforce where there are no assets. Because remember what I said, at least in most places in the US, you can still get recognition and enforcement of an award where there are assets. So this problem, this bar to recognition and enforcement really only kicks in if you want to get recognition and enforcement of award where there aren't assets. And I think 10 years ago, when this whole practice was a little bit less developed, most lawyers would say, why do you want to do that? I see the red light is on, so I'm going to wrap up quickly. But there are good reasons. There are reasons that I think we should be happy about and reasons that we may be skeptical about. The first reason is that the FAA contains a 3-year statute of limitations. And when you combine that with the jurisdictional nexus, right, if you can't find a basis for jurisdiction to get recognition enforcement of your award in the US within those relatively short 3 years, then you're just out of luck, period. And that leads debtors to engage in what I call the asset dance. It's exactly what happened in a recent DC Circuit case called Republic of Congo. Congo was on the wrong end of an award it didn't want to pay. So all it did was it kept its assets out of the US for 3 years. When the 3-year statute ran, it went back to doing business as usual. And I don't think we should be very happy about the ability of debtors to do that. Third thing that you might want to do is be able to seize assets coming into the jurisdiction. These days, enforcement is increasingly not about big, tangible assets, buildings, machinery, but are about intangible assets, things like brokerage accounts, electronic funds transfers, things that are, here and then they're gone. So rather than going through the process of getting recognition enforcement after the assets come in, you might want to set up your award, your recognition judgment, as a sort of mousetrap that closes shut once the assets get there. And relatedly, you might want to set it up in certain high-profile jurisdictions to prevent your scofflaw debtor from doing business there. This is exactly what happened in the Yukos v. Rosneft case. Rosneft, the company that inherited the assets that were stripped by Vladimir Putin from Mikhail Khodorkovsky's company Yukos, they didn't want to pay arbitral awards obtained by Yukos. Big surprise. And so what Yukos did was it converted those into judgments in New York and London, which meant that Rosneft could not process transactions in dollars or euros, which meant, in effect, it could not get paid for its oil. And so, presto, it paid the award. Those are all things I think we can be fairly happy about. There are other reasons that we might feel ambivalent about. You might want to enforce your award in the US just to get access to really broad US enforcement discovery or really broad US remedies, injunctions and turnover orders. And indeed, that's exactly what Sonera, or the Apex group, was trying to do in that case. They wanted to use the power of the US courts to find out where Kukurova's money was, and then use the power of US courts to stop them from using that money to redeem the shares it was trying to get back. And if you feel like it's okay for the US to be a sort of central clearinghouse for award enforcement, then you feel okay about that. But if you don't, then you feel less okay. And finally, what I like to call award laundering, and I think this connects well with what Maxie is going to talk about in terms of set-asides and parallel enforcement, if you have an award that has some infirmity, like a time bar or like a set aside at the seat, one tactic you can try is to find a friendly court that will convert it into a foreign country money judgment, which can then travel, arguably, without those infirmities. So, since I'm out of time, I'll quickly wrap up and say what we know from Daimler is that it creates serious obstacles to award enforcement. It forces us to grapple with this question of how we feel about award enforcement where there are no assets, and it has serious implications for drafting arbitral clauses and choosing a seat. And thank you very much.
Thank you, Aaron. And Maxie.
Well, thanks so much, everyone, for still being here. If we had a conference on a Friday afternoon with that weather in London, this conference room would be empty. So I'm very grateful to still have so many people here, as well as live, hopefully, behind the camera. I will just second what the other panelists had said before me and thank the organizers for such a wonderful conference. The professionalism with which you've organized this conference and the hospitality here in Malibu are absolutely second to none. So I'm very pleased to be back here. I'm going to talk about a topic that's actually very related to what Aaron has talked about so far. So Aaron has looked at the jurisdictional requirements in post-award proceedings, so proceedings that happen after the award has been rendered. I will look at those proceedings and more precisely the judgments that are rendered in those proceedings, and I will look at the effects that those judgments might have in other countries. Because it is not unusual to have several either parallel or subsequent proceedings, post-award proceedings, regarding the same award. For instance, you might have enforcement proceedings in one country at the aside in another country. And so the question is, what effect a judgment in one country has on the proceedings regarding the same award in another country. So I will look at these questions and I will distinguish in doing so whether or not the judgment has been rendered by the courts at the seat or outside the seat of the arbitration. So first of all, in the second category, if the judgment has been rendered at the seat, the typical situation, and Aaron has already alluded to it, is if the award has been set aside in one country and then there are enforcement proceedings pending in another country regarding the same award. And we, of course, all know that 5.1e of the New York Convention deals with this situation and says that recognition and enforcement may be refused if the award has been set aside by a competent authority. But we also all know that there's a lot of case law in the US, Baker Moran, Tamarillo, Cromonoi, Pemex, and so forth and so on, as well as outside the US who've tried to interpret what that exactly means. And the difficulty, of course, is that Article 5.1e says may refuse recognition and enforcement. And what it does not do is give any guidance as to how to exercise that discretion. To give some guidance in which cases recognition and enforcement may be refused, and in which cases it may not. And here, the idea that has been suggested by some scholars, and in particular Linda Silverman, who's already been mentioned, was to say, well, why don't we use general principles of private international law regarding foreign judgments? There is a foreign set-aside, or vacatur, to use the US terminology, annulment judgment. And so in order to decide whether or not we give effect to the set-aside in the forum, well, we apply general principles of private international law regarding the recognition of foreign judgment. That is something that we all know, depending on the jurisdiction you come from. They might differ a little bit, but they exist in every country, those principles of foreign recognition of foreign judgment. And so this is a rationale, I would say, that has gained quite a bit of momentum recently. One of the first cases where such a solution was followed was in 2009, the Court of Appeal in Amsterdam, in the UCAS case, but in a different UCAS case than the one Aaron mentioned. And here, awards rendered in Russia against UCAS have been set aside by the Russian courts, and there were recognition proceedings pending in the Netherlands. And so the question was, can we still enforce this award? And the Court of Appeal in Amsterdam has said, well, that depends on whether we can recognize the foreign Russian set-aside judgment. And in that particular case, they said, no, we can't, because the Russian courts, the decisions have been rendered by judges that were not impartial and independent. And therefore, they still recognized, or rather enforced, the award in the Netherlands despite the set-aside in Russia. That was the first case, but there are others. There is a 2014 UCAS case in the UK following a similar rationale. There is also a very recent case that I'll talk to a little bit about later, Malibu versus Egypt, of February this year in the UK, that equally follows that rationale, and the US restatement, of course, as well. Current draft follows the same principle. Now, what do we think about that solution? Well, on the one hand, it is very handy to use a pre-established framework, the judgment framework, recognition of foreign judgment framework, to interpret 5.1e of the New York Convention, because, as I said, there is no guidance how to use 5.1e really. On the other hand, I think there are some serious downsides to that solution, and I think the recent cases have shown some of those downsides. The first one is that it is fairly difficult and delicate to assess this question whether a foreign court has been impartial or independent in rendering the set-aside. All those cases concern the question whether the Russian courts were impartial vis-a-vis a Russian entity, whether the Egyptian courts were being impartial vis-a-vis an Egyptian entity, and so forth and so on. So it is a difficult question because it's very difficult to prove that the judges in a particular case have been or have not been partial and independent. And it's also a delicate question, and one that certainly is not keen to or likely to improve foreign relations between our countries. The second issue I have, and that's maybe a more important one, is even if we assume that the set-aside has been rendered by a court that was perfectly impartial or independent, or you just didn't manage to prove anything else, but came up with a really bizarre decision. Let's assume they said the award was set aside because it wasn't signed in red ink. You would say, well, that's plainly wrong. That's a wrong decision, so I should not really follow that. Well, the problem is if you apply foreign judgment principles, you're not so supposed to review the merits of the foreign judgment. Jan told us this morning, no révision au fond. It doesn't exist. You do not, most countries, it's prohibited to actually review the merits of the foreign judgment. And that's exactly what happened in the February 2015 Malibu case in the UK that I mentioned earlier. In this case, Malibu was unable to prove that the Egyptian courts were partial, and therefore said, well, but the Egyptian decision is plainly wrong. And the UK court said, well, sorry, but your argument that the judgment that the Egyptian court is wrong is not something that we will review. So I am fairly skeptical as to whether that really is a solution that one should follow. But I would be very interested to hear your thoughts, and in particular, of course, I'd be very interested to hear the thoughts of the reporters of the restatement, because I know that they have tried to fix this. The second part of my presentation is about judgments that have been rendered not at the seat of the arbitration, but outside the seat of the arbitration. And here the typical solution is that there are enforcement proceedings pending in several countries, A, B, C. And the question is if whether a judgment rendered in country A will have effect, preclusive effect, on the other enforcement proceedings in country B and C. And we all know that the principle of preclusion is quite different in civil law and in common law jurisdictions, and then maybe we want to come back to that during the discussion, but I think the aim of preclusion really comes down to the idea that we want to respect the foreign judgment. That's the idea of comity in the US. But also procedural efficiency. You don't want to relitigate issues that have already been decided. And what one might call judicial peace. At some point, the parties should just stop litigating, really. So all of this together probably makes you think, well, it makes intuitively a lot of sense to apply preclusion principles also in the context of arbitration and in the context of these judgments relating to awards. And you are right in the sense that there is a number of cases around the world that have done so, but more recent cases maybe have been a little bit more hesitant. And I actually would like to second that and say there are a couple of issues one needs to be cautious about if one follows that route. And again, this is something that, as far as I know, is in the latest draft of the restatement. So my caution, my word of caution is the following one. First of all, I wonder whether it's opportune to leave it a little bit up to a procedural timetable accident that one of those judgments will be the first to be rendered and therefore will influence the subsequent enforcement proceedings in other countries. In the Malibu decision that I mentioned earlier, enforcement was sought in Indonesia, Malaysia, Hong Kong, Singapore, and in England. And that's not unusual. So whoever comes first in deciding the enforcement judgment, would that mean that that decision then influences, has preclusive effect on the subsequent ones? Is this really what we want? And of course, you will have smart lawyers that might play around with this, and it might incite certain forum shopping, certain strategic positioning in different places. And then secondly, and maybe again more importantly, is it really right to let a foreign court decide on the question whether the forum wants to enforce a certain award? This is not about a question on the merits, where all the issues and aims of preclusion that I've mentioned actually apply. This is not about relitigating the merits. It is about the question whether the forum accepts to enforce an award under the New York Convention. Who else should be better placed to say that than the forum courts? And why should we leave that question to a foreign court to decide? And that is actually exactly what the Hong Kong court in a very recent decision has said as well. And that's a case Astra against Lippo, again of February 2015, a very recent decision. And here, the enforcement, there was an enforcement action in Singapore. The Singaporean court has refused enforcement on the basis that the arbitral tribunal had no jurisdiction. Other proceedings, enforcement proceedings in Hong Kong. And here one of the parties said this is the question of whether or not the arbitral tribunal has jurisdiction has already been decided in Singapore and therefore has preclusive effect in Hong Kong. And the Hong Kong court has said no. As far as I can read that decision, it's a very badly drafted decision, I think. But it did say, in my opinion, that the question whether or not the award can be enforced in Hong Kong under the New York Convention or the equivalent under the Hong Kong law is one that the Hong Kong courts should decide and not in Singapore. They did say that the fact that the award has been refused enforcement in a foreign country is not one of the reasons that the New York Convention contemplates. So I have my views on this, but I would be very interested to hear yours as well. And therefore, I'll stop here, and hopefully we'll have enough time, 15 minutes, for the debate. Thank you so much.
Thank you. Thank you very much, Maxie. And do we have some cards? Some cards. Well, Trey, you're the only one that had a card.
So far, mine showed up late though, so.
Questions from the audience?
Bob, can I comment maybe
Yes, of course.
on Maxie's talk? So I guess I have 3 points. One is I think I find the logical force of your argument that a mere recognition judgment of an award should not be entitled to an effect outside the borders of that state. I find the logical force of that argument sort of undeniable. Regrettably, I think at least in the US, there's no sort of statutory hook for that. There's nothing in the Uniform Act for Recognition of Foreign Country Money Judgments, money judgments and money judgments that are also recognition enforcement judgments. My second point, though, is I think there is some reason for hope. There have been 2 recent US decisions, one from a Pennsylvania state appellate court that was looking at a recognition judgment, not of an award, but of a foreign country money judgment that was seeking full faith and credit in Pennsylvania. And the Pennsylvania court said, sure, we'll give that full faith and credit. And then shortly thereafter, the DC Circuit said, no, these are not the sorts of judgments, these mere recognition judgments, they're entitled to full faith and credit. So there's now actually a sort of tension in the US courts. My third point, and my sort of one source of hesitation about this, is that even though I find the logical force of your argument extremely compelling, I wonder if these sort of award laundering judgments are being used for good and not ill. Because frequently, these judgments, the reason you end up trying to get recognition enforcement of these recognition judgments and not the underlying award is because you're trying to get around the FAA's silly 3-year time bar, or because you're trying to sort of tactically evade a really questionable set-aside at the seat. So maybe I feel like this parallel enforcement tactic, although it's, doesn't have a great logical force behind it, is being used for good and light and not dark and evil.
I think you're referring to part of my paper on parallel entitlement that I haven't really necessarily touched upon in detail during my talk. I'd be happy to expand on that as well, which is the idea of taking a foreign judgment and rather than enforcing the award, enforcing the foreign judgment that has recognized the award. And I find that difficult, but I do understand that in the US, this has a particular logic, and that is because the statute of limitation for both actions is different. The statute of limitation for enforcing awards is different and longer than, shorter, than the one enforcing a foreign judgment, and it will depend, of course, on state law as well. What I find more difficult is the situation where you do not try to circumvent the enforcement of the award. You seek the enforcement of the award, but the question is, and for example, and there you look at, does the tribunal have jurisdiction? Was there violation of due process during the proceedings? Was the tribunal validly composed, etc.? And on those issues, you have a foreign judgment recognizing or enforcing the award or refusing recognition and enforcement of the award that has decided, for instance, the arbitral tribunal doesn't have jurisdiction. And then the question is, does that determination have preclusive effect in your enforcement of the award proceeding? And the answer that some courts have given in the UK, in the US, and I believe it's the position in the restatement, is yes. It is a matter of issue preclusion that we will then accept at that determination under general principles of judgment recognition.
Which in the U.S., in those cases, would be comedy, not under any legislative regime, which makes it difficult, because comedy is very fluffy. Maybe that's not the right legal term. What do you think about that?
These might still, I mean, they might still be money judgments. And so they'd be entitled to recognition, which is what you're talking
They
about.
may be money judgments.
They might
They're-
not be.
If they're not be, then I think you're right. It would be the old Hilton v. Guillot standard, which is fluffier.
We had a card, I think.
Oh,
got
Two
sorry,
men.
sorry.
We got two.
Yeah, well, go ahead.
Are there any F2 courts analyzing the function of confirmation in F1 and determining whether it's really intended to be an extraterritorial impact? In other words, is it just designed for domestic purposes as opposed to being transnational, so to speak?
Do you want to repeat the question?
Oh, I will repeat the question. I do apologize. Whether there are any judgments that have analyzed the question whether a foreign confirmation judgment has only a territorial effect in the country where it has been rendered.
The second court to be presented
Yeah.
with.
There are, and I think in France, for instance, there is a line of case law that has accepted that for U.S. judgments, and on the basis that in the U.S. you would not only confirm the award, but enter a judgment in terms of the award. You would condemn again for, pay X amount of money. And therefore, the French court said, well, that is actually a judgment like any other, and therefore it has extraterritorial effect outside the country where it has been rendered. And for those who might not be as familiar with an international background, in some continental European countries, that's not the case, or in civil law countries, let's put it that way. What you actually do when you enforce an award is just ask for a declaration that the award is enforceable in the country where you seek enforcement. So in France, you would get a declaration that the award is enforceable in France. That judgment inherently has no extraterritorial effects. It is only designed to say the award is enforceable in France, full stop. The hesitation I have, I think that's a very logical distinction, but the hesitation I have is it actually depends a little bit on the form that enforcement has, an enforcement judgment has in the US or in France, because at the end of the day, it's the same question. It's just a matter of legal tradition that in one country you repeat what the award has said, whereas in the other you don't.
I have two questions for Aaron. I think they combine, so maybe you can take them that way. What were the incentives for the Daimler Court changing the then existing test, and what issues with the previous test did they seek to remedy? The second question is, you said under the fourth option, you can consent in a contract to personal jurisdiction, and that since Daimler was passed, you think practitioners will now do that more. Why do you say that? Why more often? Why would they?
Okay, good questions all. First, what was the Daimler Court trying to do in this sort of radical upending of general jurisdiction? I think there's a sort of good story about this and a less good story. The good story is that they were really trying to get these F-cubed cases, foreign plaintiff, foreign defendant, foreign conduct, out of the U.S. There is a strong feeling that the U.S. is not either the policeman to the world in the Kiobel ATS cases or the sort of civil adjudication center to the world in some of these other cases. It isn't, and it shouldn't try to be. And in fact, in the last 20 years or so, we've seen a big rise of these so-called F-cubed cases, and I think the court was justifiably not happy about that. So you can characterize that as a sort of modesty about the U.S.'s judicial role in a multipolar transnational world. So that's the happy story. The less happy story is that it's long been assumed that if you bounced a U.S. case out of the U.S., if you, sent a U.S. case from the Southern District of New York to Ecuador, that there it would die. And here I'm channeling my colleague Pam Bookman, who's written a paper about this called litigation isolationism. That's not true anymore. Now, if you're a lawyer who thinks you're bouncing a big case out of the U.S. into the briar patch in Ecuador, what happens is the Ecuadorian courts say, sure, we'll take that. We'll convert that into an $18 billion judgment here, and then it will come back to the U.S. under the U.S.'s very liberal standards for judgment recognition and enforcement. So that's the less happy story about Daimler, is that it's the sort of latest chapter in an attempt to get rid of these big cases against big businesses. It's just now that it's not working. And I think that partly answers maybe the second question about what are the problems with this. I mean, some of the other problems are that this old general jurisdiction standard really was incredibly broad. And many courts, commentators in the US and abroad railed against it, I think rightly so. It was a big issue in treaty negotiations. It was a big sticking point, although not, I think, the biggest sticking point in the attempt at the Hague Conference to conclude a treaty on jurisdiction and judgment enforcement. I mean, the US really was, as we sometimes are, on the sort of lunatic fringe in terms of comparative jurisdiction. As I said, however, it is possible, indeed I think it is true, that the Supreme Court sort of overshot the mark in Daimler because most of those other nations that Justice Ginsburg was looking to have comparatively bigger specific jurisdiction, whereas we now have teeny tiny general jurisdiction and teeny tiny specific jurisdiction. Now this last question about consent by contract. You haven't seen a lot of that in arbitral agreements, I think because it just wasn't a big deal. You had this jurisdictional nexus, but you had really robust general jurisdiction, so it just wasn't that tough to get your arbitral award enforced in the United States. And we actually thought for a long time that, again, the US was on the sort of lunatic fringe and having this sort of bright line rule about requiring a connection to the US to enforce an award. I think that may actually not be the case. And George, I know you're compiling information on this. In fact, it turns out that many nations require, sometimes in a discretionary way, some sort of relatedness to the jurisdiction. But I do think that now, after Daimler, this has become a big issue. And if you are an arbitration practitioner advising a client who has concerns about getting the award enforced in the US, if they think there are assets in the US or there are going to be assets in the US, those practitioners would be well advised to negotiate for this very short and simple clause. So I really do think you're going to see more of that as news about Sonera and cases like Sonera starts to proliferate through the bar.
Yeah, Chris?
A quick follow-up on that, Aaron.
Sure.
If there's assets in the United States, Daimler's not a problem, right? Because then you've got
Right.
quasi and rent type 2. So it's really only if there's no assets or you're worried about sort of doing some of these trap things to evade the statute of limitations that you want to do this, right? So,
Right.
so maybe part of the reason there's no clauses is most people are perfectly happy just going after the assets. They're not trying to do other stuff. And so if that's the case, you wouldn't expect a lot of new clauses, but you might expect some. Is that a fair?
I think
some courts said that the assets themselves have to arise out of the
Yeah, there are some wacky personal
Yeah.
jurisdiction cases. That's a different issue.
But just because the assets are here doesn't mean you can get them.
It should, but there are wacky personal jurisdiction cases suggesting otherwise.
Yeah, I mean, we know, for example, the Fourth Circuit in base metal is, I think, out on, apologies to any Fourth Circuit judges who are listening in, also out on the lunatic fringe and saying that asset jurisdiction is really not enough. But Chris, you're absolutely right. I mean, assets are enough, and again, I think 10 years ago, if you asked most practitioners who do this enforcement work, they'd say, why are you going where there are no assets? You're just wasting the client's money. Now, because of the rise of these intangible assets, and I think the rise of these sovereign and quasi-sovereign debtors, who've gotten much more sophisticated about evading award enforcement, those 7 things I put up on the screen about reasons why you might want to do enforcement where there are no assets have become much more important.
Any questions, George?
Yeah. Of course, Maxie, I love these issues that you're addressing. I'm trying to connect some dots here. So, at the outset of your talk, you were saying you drew a distinction between a judgment of the situs and a judgment of a non-situs. I couldn't tell how firmly you were going to maintain that distinction as you went through your talk. At the end of your talk, you sort of suggested, I think, that the court that confirms an award is only addressing its enforcement within the territory of that country, even if it's a situs. Because that's in the nature of that action, is to convert it into a judgment. I wonder, how willing are you to draw a distinction between F1 being the seat and F1 being just one of those other countries where the award is successively brought for enforcement? Because one way to, I'm detecting the ambivalence on your part on that, the strength of that distinction. One way to ease it might be to say, well, the confirmation judgment isn't just about enforcement, it's about validity. It's about validity of the award. And the situs court is a court that has a special claim to determine the validity of the award. So just like we would give effect to a judgment about the validity of a contract, how about we give effect to the validity, a judgment about the validity of the award by the court of the situs, but only the court of the situs, and worry about extraterritoriality with the other guys.
Yeah.
Repeat that question.
Oh, yeah,
Yeah.
well.
Go ahead.
You can do it.
Well, first of all, the first question was whether I had a distinction between judgments that were rendered at the seat or outside the seat. For that distinction, I would already be hanged in my home jurisdiction, which is France. If you only ever say the word seat, you're already absolutely killed as an arbitration lawyer. So you were absolutely right, George, in detecting some ambivalence here, because it is very difficult being French educated to even pronounce those words. But I hope, trying to, or maintaining that distinction in the sense that my first half was talking about set-aside judgments, and I didn't on purpose talk about confirmation judgments. And the second half of my talk, I was relating to enforcement judgments. Now, the reason, and that was your second question, is where do I stand regarding confirmation judgments? And I guess here, I'm not necessarily the right person to answer that question, in the sense that confirmation judgments are a fairly specific creature in the US. In many jurisdictions, you would have either a set-aside judgment and the possibility to resist that set-aside, or you have the possibility to seek enforcement of the award. But you would not have the possibility to positively seek confirmation of the award, as in a declaration that that award is valid, perfect, and stands. So that is a specific creature in the US. It might exist also in other jurisdictions that I'm not aware of, and I wouldn't know. But for me, confirmation judgments are always just the positive other side of the medal of set-aside judgments. So once we've decided how to treat set-aside or vacatur judgments, we should deal with, in the same way, confirmation judgments. I hope that answered your question.
Well, it does, except that I'm not sure what the functional difference is between saying the judgment is confirmed and an award is confirmed or an award is enforced. When you're the award creditor and you go into the court and seek confirmation of the award, you end up with the same thing that you would get if you asked for the enforcement of the award. So I don't think we have this funny vocabulary, confirmation and enforcement, but I actually think from a functional point of view, we're not that different. We use that word and it's a little confusing. But the confirmation of an award produces a judgment that is then executable.
We get a judgment that the award is enforceable.
Yes.
It's not, which is distinct in your mind from execution.
It's distinct from execution.
Right.
Yes. So I'm not sure there's a big difference. I mean, I very much appreciate your giving us an excuse for doing what we do. But I actually think, we're treating confirmation as nothing more than enforcement in the non-execution sense.
But I guess then you have given the answer to your own question, which is then we should put it in the category, just in the same category than enforcement judgments. And it's actually not really making any difference that it's at the seat or not, is it?
Yeah. So I don't want to prolong this, but I think the seat has an authority over an award that the other country where it happens to be brought and could be brought successively, I'd be prepared to make that distinction. I think some have.
But then the logical consequence would be that it is different from a pure enforcement judgment rendered elsewhere, because it is a confirmation, i.e.
No, but it's an enforcement judgment locally.
Yeah.
It's both.
It's an enforcement judgment locally, and then foreign country can do with it what it wishes.
I think on that note, I will declare a judgment, and it will not be set aside. Let's give a big applause to the panel. And a big applause to Pepperdine and the professors and students. Thank you. Thank you. Very nice.
Thank you very much.
Very well. Yeah, to be carried on. Yeah, very nice. Oh,
So Professor Coe and I have been called up to give what are said. Although I think unless Jack has particular remarks he wants to give, let me just say a couple things. First, thanks to Catherine. She's been incredible. Really, this entire event would have been impossible without her, and every good thing should be credited to her, and every bad thing should be credited to Professor Coe. But since there are not many bad things in Malibu today, there's no reason to do any crediting of the bad. And of course, we want to thank the Pepperdine Law Review and our support staff who've been doing video, and the students for showing up. Some who are not speakers may not know, but our students have been picking up speakers at the airport and bringing them back here, which is a great show of hospitality, which is what Pepperdine is known for, one, and hopefully an opportunity to create relationships which will last past 70 degrees and sunny in Malibu. What Professor Coe and I thought we might do, if there are some questions, some comments, is sort of maybe instead of having formal closing remarks for 5 minutes, see if there are other topics that people wanted to bring up. And of course, Professor Lutz cut off a great tennis exchange. My head was going back and forth between Professor Berman and Professor Scher, back and forth, but that's the kind of thing this is designed to do. Of course, we appreciate the fact that we're holding up some to getting to a nice beach location. But we just wanted to open it up to see if there are questions or comments, there are things that have been discussed that should be discussed more.
It need not be a life epiphany. Well, this may be more proof that in my life I've learned many important things from Professor Lutz, and one of them is to always remember, if you stand between the audience and the cocktail party that follows the conference in some cases, Going once, going twice.
Professor
Then-
Bashaw, do you have your hand up?
No, I'm afraid I don't.
Let me just add, to not to interrupt my friend Professor Bashaw, who I know is collecting his thoughts for a final capstone lecture. Thank you so very much for everything that everybody did to make this a success. Some of you have come a long way. The students have worked very hard, as mentioned. Some of you got up in the middle of the night to do a Skype conference with Washington, D.C. or New York, and then follow on and come here and do a conference without much of a breath in between. Others of you are flying on to London. Many of you had to do a lot of juggling to get here, and sometimes on short notice, and we really appreciate that. I'm glad to have you appreciate the hospitality and to everyone. I had nothing to do with it, so I can myself be grateful for the great administration of this, the efficiency and genial way in which everything is handled by our students and staff, and I'm glad that, as usual, you're feeling the Pepperdine effect, and I hope that you will look for an early opportunity to come back and join us again, and we will certainly keep you all in mind for the next conference we hold.
Now, I believe
When exactly?
Catherine may have a few remarks as well. Great.
Good afternoon, and thank you all for coming to our symposium. I have thoroughly enjoyed hosting our participants and learning from the presentations today. It has been an absolute pleasure to be the symposium editor for Volume 42 of the Pepperdine Law Review, because it is a role that brings together two things that I love: people and ideas. It is only through people interacting with each other that ideas become discourse. A symposium is not just an opportunity to present an idea, but to interact with it, to challenge it, to learn from it, and to be inspired by it. And I want to thank all of our participants today for coming out to Pepperdine and giving us all the opportunity to engage alongside you with these important ideas. At this time, I would also like to thank Professors Coe and Professor Childress, our faculty sponsors, for all their work in securing us such a distinguished group of scholars and practitioners, and for taking the time out of their busy schedules to plan this event. I would also like to thank our law review. This event would not be possible without our incredible staff, many of whom have been in attendance today. I believe when I last counted, at least 48 different staff members contributed in some way or another to making this event possible. Thank you for being a staff where I never had to stress or worry about whether anything was going to get done. You have made coordinating this event a pleasure. Thank you to my editor-in-chief, Sarah Gertis, who has always been there for me in planning this event, even though she is possibly the busiest person that I know. I'd also like to thank the Law Review's faculty advisors, Professor Pashaw and Professor Larson, as well as the entire Pepperdine faculty and Dean Taha for their support of the Law Review and the symposium. Many of you also have met Suzanne and McKaylee, who have been working tirelessly to coordinate this event and work with our vendors and staff for a seamless day. I owe them a big thanks, because without their efforts, this event would not be possible. I'd also like to thank all the staff at Pepperdine who've been working behind the scenes to do things like create a website, a brochure, and facilitate the live stream. The Law Review appreciates your efforts. I would also like to thank the Straus Institute and OG Mid listserv for letting us publicize this event through them. Finally, I would like to thank all of you who came out today and joined the Law Review and our panel participants in engaging with these important ideas. We hope you enjoyed the event, and please look for the papers presented today to be published in volume 43 of the Pepperdine Law Review. As my many thank yous indicate, this is an event where people came together to make it possible to engage with ideas, and I could not have asked for a better team. We hope you enjoyed the Law Review Symposium on International Arbitration in the Courts. Thank you for your time, and we hope you have a good evening.